What's up? What's up? How you doing? You know what time it is. It's back to matter at hand. We'll go over something that pretty much is relation to what we was talking about last week in Home 9 Yards, the last couple of videos. And it basically deals with the fact of like when they bring you upstairs for labor relations hearing or anything, and you filed a complaint prior, especially if it's a whistleblower. You gotta understand, in being a whistleblower, it has to be a rule, regulation, and law that was violated, and then the fact that they try to retaliate against you with that, which would kick in the whistleblower. That's the deal. Certain people are like, oh, it's got to be something major. No. Did they violate any rule, regulation, or law? Did they break any rule, regulation, or law? Yeah. Okay, so there's your initial complaint. That doesn't have to be a whistleblower, just your complaint. Now, on the action of retaliation, bingo, we have action. You get them on that. So basically, I'm gonna go into Civil Service Law, Section 75, right, which also discusses 75B, which kicks in the whistleblower. And this is it right here. If you can see it, you can PDF it, where it says Civil Service Law, Section 75. And I'm basically going to read to you from this. It says, protected by Civil Service Law, Section 75B. The arbitrator or hearing officer is mandated to dismiss or recommend dismissal of the disciplinary process and, if appropriate, reinstate the employee with back wages. In addition, in the disciplinary arbitration context, the arbitrator is authorized to take other appropriate actions as to permit in the collective negotiated agreement, so in your collective bargaining agreement, similarities when determining a non-disciplinary grievance, all right, a violation of Civil Service Law Section 75B, an arbitrator is granted the authority to take such action and remedy the violation as permitted by the collective negotiating agreement. Basically, when you go to 40 Rector, they could bring about the remedy, once you point out the fact that you filed a complaint under whistleblower, you filed a complaint you just filed a complaint, and then the mere fact that they went too far and they kicked in the whistleblower. Now, what we're going to talk about in this is the real deal of the adverse actions. See, because once you filed that complaint, right, they gotta follow the policy procedures under civil service law. And right here it says the scopes of civil service activity protected under Civil Service Law Section 75B prohibits the public employers from terminating or taking other disciplinary actions or other adverse personnel actions against a public employee because the public employee disclosed information to a governmental body regarding a violation of a law, rule, or regulation, which creates or presents a substantial and specific danger. So when old boy used this car in a threatening manner, and I filed the report, which using the vehicle, it basically broke the traffic law and it also broke penal laws. Okay, so and it was a danger because it was the mere use of the vehicle in a threatening manner would bring about menacing. It would bring about reckless endangerment in the whole 9 yards, fear of imminent physical harm. That's injury, physical injury. Okay? So basically, we're going to go back to specific danger to the public health or safety, or which the employee reasonably believes to be true and reasonably believes constitutes an improper governmental action. So if they brought any charges against you and they continue when they wasn't supposed to, the improper governmental action, that would kick in because they were supposed to stop. So we're going to say improper governmental action includes any action which is in violation of any federal, state, or local laws, rules, or regulations. All right? These are the key things you got to understand. The whistleblower statute prohibits public employers from taking any adverse personnel action against a public employee who engages in protected conduct under the status. Personal actions is defined as any action or action affecting compensation, appointment, promotion, transfer, assignment, reassignment, reinstatement, or evaluation of performance. So basically, that will be what constitutes an adverse action. So we're gonna go forward. We're gonna go forward right now. So let's go to the fact of if you see one of the posters I put up is with the schedule. So we're gonna basically go to the fact that the labor relations specialist held a hearing or disciplinary conference, meeting, whatever you want to call it, with the employee and representation from Teamsters Union. Now, here's the problem right there. See, because you got these people that's coming down that's representing you, and they don't know. You know what I'm saying? They're coming in there and they just go along with it. No. If I'm paying for representation out of my union dues, you need to understand what it is that you're supposed to do and your job responsibility in reference to, how would you say, representation or under litigations for my rights and of employment here. Okay, under the corporate compliance policy, under the signed contract agreement, you need to understand this. You need to know this. All right, instead of playing that back and forth handball game between you guys. And then you forces us to go and do our research, and then you try to bank on it being, well, it's too late. There's nothing you can do. Come on, I'm about to give it to you good right now. There is something you could do because of the mere fact that they deprived you of a right. They deprived you of a right. Remember, and when you're being deprived of the right, it also falls under U.S. Code 42. I love to call it the Jackie Robinson. U.S. Code 42. Deprivation of a right or privilege. A right or privilege. Okay? That covers Civil Service Law, Section 75B. If you're an employee, you're entitled to a privilege for certain things under rules and regulations. It covers that. It covers that. So you need to hold them accountable to that. Under that. And there's no statute of limitations under that. That opens the door. Now, moving forward, we're going to go to the fact that the specialist, the labor relations specialist, continued. She held the hearing, and I explained to her at the beginning of the hearing, I have a whistleblower, I have a filed EEO complaint in place. Okay? With that being said, it was her responsibility of her corporate compliance policy to call downstairs and is it filed here? Yes, filed here. And contact the facility's EEO in reference to that matter before taking actions. Well, you get these people who get in place and they say, well, I'm going to do what I want to do because I can go beyond that. Not a problem. Not a problem. Go ahead and do what you want to do. So basically, after she was informed in the presence of the union, and they have hidden recording devices in there, she continued. Not a problem. You continue with it after I informed you? Not a problem. Okay. The mere fact that you continue, and then basically you're brought up that you're going to be suspended from this period of time to that period of time. The mere fact of taking suspensions would bring about you taking actions. while the whistleblower is in place. That would be taking adverse actions. Now let's look at the key things you're taking actions for. You're taking actions for time and attendance, because you're spending. You look at the date of suspension. That is for actions that was caused on the time and attendance. Yeah, that was from 2008. That was basically the retaliation from when old boy took his car and tried to hit me with his car. And then I filed a complaint against him. So he then brought up time and attendance charges that he caused because of this mere fact. Let's go to the first one. Upon my return, you denied me access into the paid parking lot, for which I was parking in 2 years and a month before you start working. Yeah, that would be the probationary employee. 2 years and a month before the probationary employee start working there. All right, I was already parking in that lot. So when he used his bully tactics, I could just do what I wanted to. No problem. No problem. So he went ahead and he told the officer and parking attendant and supervision, I don't want him parking down there. Tell him to go park in the visitors parking lot or park on the street. I don't want him parking down there. Do you have any cause or reason? Do you have any supported documentation for said actions? Any reason for him to, for you to basically deprive him of this action? I'm the director. I could do what I want to do. Really? I don't see your name on the side of the building. That means you're an employee. Am I correct? Okay. So, in their actions of depriving me of parking in my assigned parking lot, for which I was already parking and have a history of, that would bring in that U.S. Code 42, depriving me of a right, because every day I would come there, show up on time, and try to gain access for where I paid for. I paid for the month. I'm supposed to go there for the month. You have no reason, you have yet to show reason or cause for me not to park there. Further, you have no probable cause. B, it's a signed contract agreement. So you breached that signed contract agreement while you were on probation. And they knew this. And they still allowed you to stay there? Who did the hookup? Not a problem. Let's go forward. So you then use that time and attendance to bring me up on charges for lateness that you caused. I'm showing up on time. Yo, just don't let him in. Oh, you want to build a case? Not a problem. Remember, we're going by first action. Your first action was in violation of the corporate compliance policy, as well as in violation of laws, let's say state and local laws. And then it even moved up to a federal law, which trumps all of those laws, because U.S. Code is a law of the land. Yeah, that U.S. 42? Yeah, that's a constitutional law. Yeah, with no statute of limitations. That's a constitutional law. That's a law of the land. So you even went in, you violated that. Not one time. That was the first time you did it. Then we're going to move forward where you bring me up on charges. Yes, yes, yes. For this hearing. Yes, yes, yes. And this is after the whistleblower kicked in. Because the first action is when you use your vehicle. The second action is upon my return and you deprive me of parking. So that kicks in that whistleblower once I told the two captains. That kicks that in. Now let's move forward. So we in labor relations. And the labor relations specialist is informed. But they want to continue. You're in labor relations. You know that I'm a permanent employee under civil service law. So you should be well aware of, of your standards in reference to civil service law and what you're supposed to do and how you're supposed to deal with it. But, these people are dumb people. We're just going to keep on going. Not a problem. Not a problem. So you too going to deprive me of civil service law section 75B, right? Because it says right there, you can't take no adverse actions. You're supposed to stop, but you continue. Not a problem. So when you deprive me of Civil Service Law Section 75B, you deprive me of this first one, you're automatically violating U.S. Code 42 by depriving me of a right or privilege. Okay, these guys is crazy. They break so many laws when they do their actions. Now, let's move forward. You give me a suspension for the month of May. Which, when I came back, he did it again. You're suspended. Here's your time. This is when you're going to be out. This is what you're getting. Right. So, you're now forcing me to take the suspension, right? Yeah. Hello, adverse actions. That will be an adverse action. Why? Under civil service law, you cannot take any adverse action. The mere fact to issue that suspension for that month would constitute improper governmental actions, which is an adverse action. Got it? So that would be number 3. And in doing that, what is that? Abuse of power and authority. That would be in violation of a Mayor Order, Executive Order number 16. Why? Corruption and abuse of authority. I don't know what's going on over there, but you guys really did a real crazy number over there. I don't know, but I do know it's all still open, and I'm not the only one. I would say go over your documents. Anybody that's going through stuff like this, go over your documents in the whole 9 yards, especially if you're civil servant. If they deprive you of that and you can point that out, contact your lawyer. If not, contact somebody else that can assist you with that, where you can get a remedy. Yeah, you need to get that remedy. See, because if you even went to 40 rector and you go inside the court, even though you're going into court, for court to function in that, the remedy is already snatched. You don't even know it. It's snatched from your strawman account and placed on the side. It's placed on the side under your surety bond. Yeah, under the surety bond, which brings about the remedy. And you would have to use Article 78. So you don't even have to go to Article 78. Just show the deceptive practices by these guys. If you can show the deceptive practices by these guys, oh wow, I'm making this shake. You can show the deceptive practices by these guys, you got them. Under subsection 349 of business law, subsection deceptive practices. They done did it more than one person. You could just prove that. You also got executive law number 6312. It's like 6312, but 6312 in that, where they're using deceptive practices. And both of those two laws, the state attorney general kicks in right there. And then you can go after them on your own, but the state attorney general comes after them. It's equivalent to the U.S. Code under Title 18. It'll be U.S. Code 242, which is deprivation of a right or privilege. But that will be a governmental entity going after another governmental entity. But under 42, that would be you giving the right to use your name to go after them, for them depriving you of a right as a person, as the live person on the private side, as the live person, not as your straw man, as the live person, as they deprive you of a right, your God-given right, and them using deceptive practices. This is something you need to just do your homework on and learn this. You know, I was beating my buddy in the head how he was violated, and I went. I said, "How did you? You know?" He's like, "I was arrested." "How was you arrested?" "You on your own land." "Oh, well, they said this and that. You better read the state law." And I had to pull it down and read the state law form. You wasn't supposed to be arrested. Why? Because how did you get released? The judge knew that the officers violated the rules, regulations, and laws. They violated your rights. So the judge was like, kick him loose. Why? Kick him loose. Why? So we won't be sued. And I'm not being sued. So, going back to what I was talking about under that, adverse actions. Remember that. Remember that under Civil Service Law, Section 75B, under your corporate compliance. That's why I always say download your corporate compliance policy. Download your corporate compliance policy. Download your signed contract agreement. Download your representing unions corporate compliance under their fiduciary and representation for you. Okay, and then you read them. Put them on your phone and read them daily till you understand it. And that, because then when you understand it, they can't pull the nonsense that they pull. You know, I mean, the guy who pulled the nonsense on me, he truly thought he was going to get away with it. He truly thought it. But I'm watching every action he did. There was something else that slowed it up. I'm not going to lie. But that was another city agency who violated their corporate compliance policy, which puts me in this jam. Oh, my God. The city, how can you work for the city and just say, I don't care? Them too, in their actions was gross negligence, gross misconduct, and that. You know, which brings about a breach of duty, breach of contract. But they look at the average person. Oh, hey, nothing. They went inside and looked at my uniforms like, oh, he stole them. No. That was the real deal, baby. Real deal. Not just for one entity, neither. That's a good thing about it. That's a good thing about it. Do your homework. All right? Remember, adverse actions. All right? They're not supposed to take adverse actions against you. Okay? On the subsection 75B. Okay? And if they did, then basically find out what it was they actually did and how they did it, and then see if they violate in their actions in doing so, what it constitutes violation of that U.S. Code 42. You would bring that back up. You know, as far as like under your Article 78, you'll bring that back up in the whole 9 yards, just to stop their nonsense. You could bring it to a close. All right. So on that note, I'm about to be out of here. I mean, it was simple. You know, I ain't gonna flood your head with everything and that. So you know the deal. The facts cannot be altered nor denied. Y'all have a great day. All right, and I'm out.